Michigan no-fault benefits are basically three types of benefits. The first type of benefit are wage loss benefits, where if a person's injured in an auto accident and they're disabled, they can get up to 85% of their gross wages for the first 3 years after the accident. The second type of claim is a claim for medical expenses. And under Michigan law, the medical expense coverage is unlimited. So it does not matter the amount of the bills or how long into the future someone is incurring bills. There will always be coverage. And if a young child is 10 years old and gets in an accident and they need medical treatment for their injuries 20 years later, there will be coverage from the insurance company for their medical expenses. The third type of claim is a claim called household services or replacement services, and what that is if a person's unable to perform household chores for themselves or dependents, they can get up to $20 a day for the first 3 years after the accident, as long as they're disabled and they need these chores. There are many types of accidents involving vehicles which would allow someone to make a claim for no-fault benefits. The most typical type of claim is when someone's in a car accident where they're a passenger or driving a car and they're struck by another car and they're injured. Other types of situations would be if someone's a pedestrian. They're walking or they're riding their bicycle and they're hit by a car. They can make a claim for no-fault benefits in that situation. If someone is getting out of their vehicle or getting into their vehicle, and for example, if they slip on ice and they injure themselves while exiting or entering the vehicle, they're entitled to get no-fault benefits. If someone is taking groceries out of the trunk of their car and they hurt their back, they're entitled to get benefits if they're loading or unloading their car and they get in an accident. So there are many different types of situations where individuals can make claims for no-fault benefits. Even if the person who was injured in the accident was the one who caused the accident or was at fault in the accident, that injured person is still entitled to make a claim for no-fault benefits for the wage loss, medical expenses, and household services. So, for example, there are cases where I've had clients who've been drunk and caused the accident. Even in that situation, they were entitled to get no-fault benefits under Michigan law. If a person is at fault in the accident, the benefits are not lowered. It doesn't matter. Michigan is a no-fault state, and the laws were created in 1973, and it's a comprehensive system, and it was based upon providing quick, prompt benefits to people who were injured in accidents, whether or not they were at fault in the accident. If it's a one-car accident, the injured person is still entitled to make a claim for no-fault benefits and still entitled to get their medical expenses paid and to get their wage losses paid and also to make these claims for household services.